G'day everyone, Anthony Marinak's my name, and welcome to the second of my 2-hour law courses. As with the previous one, the idea here is to gallop through an entire university law course in 2 hours. This time, we'll be looking at intentional torts. Now, most of you in most law schools will find that your study program includes 2 torts courses. They might be called Torts A and Torts B, or Torts 1 and Torts 2, but you generally find that one of those courses is all about what we call the intentional torts, and the other one's about negligence. I'll describe the difference more once we get underway. I'm hoping that a future 2-hour law course will be done on negligence. Now, as I said at the start of the previous 2-hour law video, these videos are a great way to get an overview, and they're great for revision, but we're doing this in 2 hours here. Obviously, the detail is heaps less than what you'll get by studying each week at uni. So this video can help, but it can't replace an entire detailed course in tort law. Finally, as always, along the bottom of the screen, you'll find the statutes and cases which support the points of law that I'm making in my description. Take a note of those, and you can go looking for them to help fill in the details. The law discussed in this video is Queensland law, but torts is very similar throughout Australia, and I've done my best to illustrate those areas where the law in other states is different. I understand the law to be correct as at the 30th of June 2018. Alrighty, 2 hours. I'm up for the challenge again. Let's start the clock. Every torts course in the whole world starts out by telling you that the word tort is a French word meaning wrong. It's also customary to make a joke about how a tort is also a rather yummy cake. So a tort is something that a person does wrong to another person, with the result that the victim can sue them for a remedy. Now that's a simple enough explanation, but it's not an altogether helpful one. I would prefer to say that everyone in our community has a bundle of interests. We have an interest in our own body, for instance. We don't like it when others hurt us or touch us without our permission. We have an interest in our own stuff. If we own things or possess things, well, others shouldn't use them or take them without our agreement. We have an interest in our land. We don't want others coming into our homes or onto our lands without our permission. We have an interest in our reputations. We don't want others trashing us. We have an interest in fair economic transactions. We don't want to be ripped off. We sometimes have an interest in other people. We have an interest in the communal environment in which we live, and we don't want others harming that communal environment, especially where that directly affects us. Now, once upon a time, back in the Dark Ages or something, if a person harmed us, then we'd probably take it unto ourselves to go and do something about it. We might steal our stuff back, or challenge them to a duel, or stab them in their sleep, or set their house on fire. All very satisfying stuff. But the rule of law is supposed to create peace, order, and good government. So the law has to provide people who have been wronged with things they can do about it without burning one another's houses down. That's torts law. Tort law says, here are a range of interests which the law will protect. If someone messes with those interests, you can sue them and obtain a remedy. Now, some of you will straight away see that tort law overlaps with some of the other types of law that you'll most likely be studying in your first year of law school. For instance, if someone was to physically harm you, or if they were to steal your stuff, then they'd be committing a criminal offence as well as a tort. In the same way, quite often, a person who commits a tort against you might also be breaching a contract with you. For instance, if you put a beautiful dress in to be dry cleaned, and then saw the dry cleaning staff member wearing your dress at a social function, well, they'd be committing the tort of conversion, but they'd also potentially be breaching your contract. The cool thing is that where these causes of action overlap, you don't have to choose. Both remain open. So let's say someone does hit you, and as a result, you end up with a big dentist bill. Well, the police might charge them with a criminal offence, but that criminal offence is between the Crown and the defendant. You as the victim, well, you're really just a witness for the prosecution. Under tort law, though, you can still potentially sue for damages for the harm they caused to you. We'll look more at the detail later, but for now, just understand that tort law often does overlap with other areas of law, and that's okay. The victim will generally have access to both. We traditionally divide torts into what we call intentional torts and negligent torts. Intentional torts, which are the ones we're discussing in this video, require a certain level of intention to commit the act or the omission which results in the harm. Negligent torts, on the other hand, don't require intention. Negligence occurs when a person has a duty of care towards someone else and they fail in that duty and the failure causes harm. For the intentional torts, there are a few fundamental things to think about. First, the law is only interested in whether the person committing the tort, we call them the tortfeasor, intentionally committed the act. The law isn't usually interested in whether they intended the harm that followed. So let's say I threw a rock in your direction to give you a bit of a scare, but my aim was off and I clocked you between the eyes. Well, that'd still count as intentional. There are a couple of torts where this isn't true, and I'll mention those later, but the basic principle is that we are only worried about whether the act was intentional, not whether the harm was intentional. Second, it's sometimes enough to be reckless. So let's say I was at a concert and there were a bunch of people there with phones, but just to be smart, I was spraying people with a water pistol. I might not have intended to spray anyone's phone, but I knew it was a pretty solid possibility and I didn't really worry about it. In some cases, recklessness might theoretically be enough for the act to be intentional, but most recklessness cases are more likely to be sued as negligence. Without an intentional act of some kind, you usually don't have an intentional tort. Finally, one of the beautiful things about studying torts is how structured they are. For this reason, any of you who enjoyed criminal law will almost certainly enjoy torts as well. Every intentional tort is broken down into a number of elements. We're going to go through those elements for every intentional tort. To work out whether an act was tortious, that is, whether it's a tort and whether it gives rise to liability, all we need to do is break the tort down to its elements and look for evidence to show that those elements are present. From a conceptual perspective, it's dead easy. There are a few things I want to look at briefly before we get stuck into the individual torts though. First up, anyone who knows my teaching knows that I'm a sucker for a bit of history. You can't understand the law without understanding its history, especially tort law. You see, tort law is some of the oldest law we know. The very oldest written laws that we know about are the Code of Hammurabi, king of the Babylonians. Now these laws were written nearly 4,000 years ago, and most of them are basically tort law. For instance, law number 245 says, if anyone hire oxen and kill them by bad treatment or blows, he shall compensate the owner, oxen for oxen. In other words, if you damage someone else's stuff, you're going to have to compensate them. Now the Romans, who are much more likely to have provided a basis for our English-based system of law, they produced the Lex Aquilia. That's a system of laws which was also about compensating people for damage unlawfully inflicted by the defendant. In our terms, by the tortfeasor. So you can see, for thousands of years, laws have looked for ways to provide compensation to those who are harmed by the unlawful actions of others. In the English system of law, this resulted in what was called the writ of trespass in the old writ system. This writ first came on the scene during the 1200s, so in the same century that Magna Carta was signed. So again, very old. The writ of trespass allowed people to claim compensation for interference with a person or their goods or their land. The legal fiction was that the tortfeasor, by engaging in this interference, had interfered with the king's peace, which is why the courts could get involved. In reality, the courts were more likely involved to prevent breaches of the peace, which would occur if people just sorted it out for themselves by burning one another's house down. And second, the courts wanted the income from the fees paid by those bringing cases before the courts. Over the centuries, another writ developed, referred to as an action on the case. That's a very odd description. And this writ was used when the harm was caused by one person to another, but where they couldn't necessarily show a trespass. This writ ultimately became the tort of negligence. In any event, you can see that tort law is truly ancient. And despite the passage of thousands of years, it still basically does the same thing it's always done. It requires tortfeasors to compensate their victims for interference with their protected interests. In recent years, though, parliaments have really changed the game when it comes to many types of tort. I know you're probably busting for me to start talking about the actual torts themselves, but bear with me, this bit really is important. You see, there are a bunch of different situations where one person might cause harm to another, and where the victim of that harm might be able to claim compensation or other forms of support under a parliamentary law or a statute, rather than relying on general tort law. So it's important to be aware of these up front, because the last thing you want is to be rushing off to use tort law when in fact there's a statute which provides your client with a different scheme of compensation. So let's look at some. All states in Australia have established legislation requiring the operators of motor vehicles to have third-party insurance relating to those motor vehicles. That insurance covers the damages to some other person, the third party, if your car injures them in an accident where the driver of your car is at fault. These schemes include simplified, more efficient procedures for resolving disputes about those claims. In addition, there's a national scheme called the National Injury Insurance Scheme, which provides support to those seriously injured in motor vehicle accidents, regardless of who's at fault. Now, neither of these schemes actually stops a person from taking action under traditional tort law, but they represent such an improvement that virtually every traffic accident is resolved under the legislation. If a person is injured in their workplace, then in a similar way, their compensation, the costs of their treatment and rehabilitation, and the process of returning them to work is all now managed via a statutory scheme in each state and territory. The scheme is funded by employers who are required to maintain appropriate insurance arrangements. Again, while this scheme does not actually prevent people from taking action under traditional tort law, the scheme is generally so much better that virtually everyone stays under the legislation. All states have established victims of crime support schemes. In Queensland, the scheme is operated by a government entity called Victims Assist, and it provides compensation to victims of violent crime. It doesn't provide the same sort of compensation for victims of non-violent crime. The amounts payable are capped, usually at $75,000, and the government itself then goes after the offender for the repayment of that money. So the advantage is that victims don't have to go to the time and expense of legal action while trying to fund their recovery in the meantime. The disadvantage is the limitation on damage. However, again, this legislation doesn't stop people from also taking action under tort law. Next, there's a joint Commonwealth state scheme involving all the states and territories called the National Disability Insurance Scheme. This actually isn't an insurance scheme at all. It's funded by the Commonwealth and the state governments, and ultimately it's funded by the taxpayers who earn enough that they're required to pay the Medicare levy. Essentially, the NDIS exists to provide necessary and reasonable supports to people with disabilities. This includes people with congenital disabilities, but also people who have disabilities which come about because of the actions of others. So the sorts of things we'd normally think about in the area of torts. Now, the relationship between the NDIS and tort is a little different, because a person receiving support under the NDIS can actually be required to take action, including under tort law, to obtain compensation for whatever's caused their disability. That compensation money then goes to fund their NDIS support. Finally, the Australian Consumer Law, which applies right across Australia, contains provisions which allow consumers of goods and services to obtain compensation and other remedies if the goods and services don't work, or more importantly for our purposes, if they end up actually causing harm. Now, these consumer provisions are much more relevant to negligence, which is the other half of torts, but I still want you to know that legislation's out there. So overall, you can see that the parliaments in Australia have been quite active when it comes to reforming areas of the law relating to the provision of compensation for people who've been harmed by others. The tort law we're going to be talking about in this lecture has to exist in harmony with those other schemes. All right, enough of the preliminaries. Let's get stuck into some torts law. At the outset, I said that one of the purposes of torts law is to compensate people for various types of interference. The first of those types of interference we're going to look at is interference with the person themselves. In many texts, you'll see this referred to as trespass to persons, which is language harking back to that old writ of trespass. Interference with the person starts with a fundamental philosophy that the law should absolutely protect each individual person. Nobody should be allowed to touch you or take actions which hurt you unless you consent or unless they have some other lawful justification. There are three torts relating to interference with a person. They're called assault, battery, and false imprisonment. They each require a number of the same elements to be present. First, they each require a voluntary act. This means the tortfeasor must intend their conduct. So to take an example from the cases, if a person is having a medical fit and they strike somebody through the spontaneous action of that fit, it's not a voluntary act. Second, the voluntary act needs to have what we refer to as an injurious effect. So it needs to cause some consequence that the law will protect. Now, as we go through each tort, you'll see that the injurious effect changes for each tort. The injurious effect has to immediately follow on from the act. So if there are intervening actions, like a chain of events, between the act and the injurious effect, there's probably no liability. Finally, for these torts against the person, it's necessary to either intend to cause the injury, or alternatively, the tortfeasor, the wrongdoer, needs to be reckless as to the injury. So basically, a tort against a person occurs when one person performs a voluntary act which has an immediate injurious effect upon another person, and where they intended the injury or were reckless as to the possibility of the injury. Let's start by looking at assault, because assault is not actually what most people think it is. Assault is the intentional offer of a threat of force or violence to another person who reasonably believes that the violence will be carried out immediately. So assault doesn't require any touching at all. Assault is about the threat. And you can see why. If I point a gun at someone, well, they're entitled to be terrified. And they're entitled to the law's protection from that terror. And that's the case whether I intend to shoot them or not. Let's break down what we mean by assault. The first element we need is an intentional offer. How might this happen? Well, there are two ways: through words and through conduct. So if I shouted at you, "I'm going to punch you," then that would be an intentional offer of that threat. Similarly, if I said nothing but I shook my fist at you in a way that made it clear that I was about to hit you, well then that too would be an intentional offer. More often though, words and gestures happen at the same time. And those words and gestures can actually affect one another. So for instance, in an old case called Reed and Coker, the plaintiff was surrounded in a workshop by the defendant's workmen, who told him to leave or they would break his neck. You can see in that case the words and the actions went together, so that was definitely an assault. In another, even older case though, the defendant, having been provoked by the plaintiff, laid his hand upon the handle of his sword and said, "If it were not a siege time, I would not take such language from you." In other words, the circuit judges were in town, so it was the worst possible time to be killing someone in a duel. And so while his gesture was threatening, can you see that his words actually undid the threat? He was saying, "I'd really like to pull out my sword and cut you in half, but because the judges are in town, I'm not going to." So there was no offer of a threat, and therefore no assault. The second element is that there needs to be a threat of force or violence towards the other party. So if the threat is something other than force or violence, it's not an assault. One of the more interesting examples there is a threat to take a photograph. The other person might not want their photograph taken. It might be a threat of something unpleasant, but it's not a threat of force or violence, so it's not an assault. The third element is that the other party has to reasonably believe the threat can be carried out. If someone makes a threat towards you and you don't for a moment believe they could carry the threat out, then it's pretty hard to suggest that the threat has caused you any particular terror, isn't it? Bear in mind the key word, reasonably. So the question here is not whether this particular victim believed the threat could be carried out, but whether a reasonable person would have believed that. The classic case here is a pistol, which might not even be loaded, being pointed at a victim. Well, the reasonable person in that situation would fear the threat was likely to be carried out. They can't be expected to have any idea whether the weapon was loaded. The final element is that the victim has to reasonably believe the threat can be carried out imminently. But what we mean by imminently is a bit fuzzy. It doesn't have to mean immediately in the sense of the next few seconds. However, the threat does have to immediately play on the victim's mind, and there does have to be a certain continuity between the threat and the likelihood of the violence. So, for instance, in Zanker and Vartokis, the defendant had trapped the plaintiff in his car. He'd unsuccessfully demanded sexual favours from her, and then speeding along he said, "I'm going to take you to my mate's house. He will really fix you up." Now, even though that threat might not have been resolved for another 10 minutes, half an hour perhaps, it immediately cast terror upon her and she was stuck in the situation with no prospect of escape in the intervening time. That was an assault. The essence of assault, though, is threat and apprehension. Once the force and violence becomes real, you got yourself a battery. A battery is an act which intentionally and directly causes offensive physical interference with the plaintiff's person. Now, we've already talked about what we mean by intentional, and we've already talked about what we mean by direct. So let's assume those two are covered off. The third element we need to look for in a battery is offensive physical interference. Notice how it doesn't actually require harm. It doesn't require pain or bruising. In fact, the form of words used is that the least physical touching can constitute an assault. The slightest brush of a defendant's fingertips against the plaintiff can be enough to cause offensive physical interference. Now that makes a lot of sense because the law doesn't just want to protect us from being harmed. The law says that we are each inviolable. Each of us gets absolute protection of our bodies. We get to decide who touches us. And if someone touches us in an offensive way, it matters not that they did not inflict some physical harm. And yet, touching is also a very normal part of our social engagement with people, isn't it? I mean, by going out into the community among other people, we kind of accept that under certain circumstances we might touch and be touched. Someone might touch you on the shoulder to attract your attention. A complete stranger might reach out and grab you if you're about to fall. Getting on the train or going up to the bar or sitting next to someone on an aircraft, these are all situations in which we generally accept that some level of social touching is going to occur within certain social boundaries that we all tend to know. The law says that this social touching does not constitute a battery because it's not offensive. But even this sort of touching, normal social touching, might become offensive if the person touching continues to do so even after the other person has made it clear that they're uncomfortable. Touching someone to get their attention becomes offensive if they've made it clear that they do not wish to give you their attention. This in turn means that the notion of offensiveness might be different in different cultural contexts. For instance, as a man, for me to physically touch a Muslim woman might for her be an offensive contact because of religious rules. In the same way, for a woman to touch a Buddhist monk would automatically be offensive. If you knew that your touch and the nature of your touch was going to be offensive and you went ahead and did it anyway, that would definitely be enough to constitute battery. The final thing to note is that while the action must be direct, that doesn't mean that the tortfeasor must actually touch their victim. Using an implement, or throwing or firing or launching a missile of some sort is just the same as striking the blow personally. Shining a bright light or a laser pointer in someone's eyes would be just the same. If you've directly caused the contact, that's enough. The last element is that the interference has to be with the plaintiff's person. Now that doesn't say the plaintiff's body. Contacting, for instance, their clothing or something they might be carrying would also be enough. You can't get out of battery by making a sneaky argument like, I didn't hit him, I only hit his shirt. In the case of Purcell and Horn, Horn's wife Elizabeth threw a bucket of water, the complaint said boiling water, over the plaintiff. It ruined his greatcoat, and he was able to sue her as a trespass to the person, not merely a trespass against his goods. The third of our torts against the person is what we call false imprisonment. Bit of an odd title really, because there's nothing false about the imprisonment. Really we should call it something like improper imprisonment, but you get the idea. False imprisonment is an intentional and direct act, there's those words again, which causes the total restraint of the victim within an area defined by the tortfeasor for any length of time. All right, let's break that down. Again, we're going to skip over intentional and direct, but if you're looking at false imprisonment for a problem question or for a client, you'll definitely need to be looking for an intentional act which directly causes the false imprisonment. So the third element then is the total restraint of the victim. What do we mean by this? Well, for starters, we don't necessarily mean that the victim must be bound hand and foot. What we mean when we talk about total restraint is that they have been secured in an area from which they cannot leave. So for instance, in a case that we've already met, Zanker and Vartokis, she was locked in a moving car and the door handle on the door was not operating, so she'd been trapped. If there's a way out for the person, even if it's not a way out they would like, well then it's not false imprisonment. So in Bird and Jones, the plaintiff was prevented from moving through a public park because part of it had been roped off for paying spectators of a boat race. He was allowed to go in any other direction though, and so there was no imprisonment. Similarly, in Balmain, New Ferry and Robertson, the plaintiff, Robertson, was held not to have been falsely imprisoned on a wharf in Sydney because he realistically had the option of swimming the short distance from the wharf to the nearest point of land if he truly wished to avoid paying to make his way through the turnstiles. The fourth element, confinement within an area defined by the tortfeasor, really falls out of that discussion of total confinement. If I am confining you, then part of what I'm doing is establishing the boundaries of how far you may travel, whether it's keeping you in this car or this room or on this wharf or in this plane. If the tortfeasor can't define the area that you must remain within, then it's quite likely that you're not in fact totally restrained, isn't it? The final element is for any length of time. Now this is really important. False imprisonment might in fact occur for just the briefest moment. If there is any period of time in which the victim is not free to leave, then they have been falsely imprisoned. One last thing with false imprisonment. Strangely enough, it's not actually necessary that the victim should know at the time of their imprisonment that they're being imprisoned. In the key case, Mearing and Graham White Aviation, the plaintiff was being interviewed by his employer in a closed office, and he didn't know that there were big burly staff members posted outside to stop him from getting away. Can you see how he's been falsely imprisoned? He had no realistic way of leaving that room if he wanted to, and yet at the time, he had no idea that he was being imprisoned. Now obviously the victim would need to find out later, or else why would they bring the action, but at the time, they can be blissfully ignorant. So those are our three torts in the category of interference with the person. Assault, which is based on a threat, battery, which is based on offensive physical contact, and false imprisonment, in which a person's liberty is taken away. There are a number of defences open to a defendant accused of these torts, but the tricky thing is that the burden of proof swaps over. So the defendant must prove, on the balance of probabilities, that the defence applies. Let's look at those defences briefly now. The first one to look at is consent. You see, sometimes we do consent, particularly to battery. Anyone who's ever stepped onto a football field or taken a karate lesson or had a massage or visited a doctor has most likely consented to types of touching or force which go well beyond normal social touching. But they're not torts in that context because there's consent. Next, there is necessity. Now this defence applies if the actions of the defendant were reasonably necessary for the preservation or protection of life, and if the plaintiff was not able to give or withhold their consent. This classically occurs in a situation of a medical emergency such as a car accident. However, if the plaintiff's lack of consent is known, necessity will not apply. This happened in Millett and Schulman, a Canadian case, in which an unconscious patient was carrying a card stating that she was a Jehovah's Witness, and she did not consent to blood transfusions. A transfusion that was given to save her life was still an assault. Next, there's self-defence. You can rely on self-defence in defence of yourself, in defence of others, and in defence of property. But the force you use has to be no more than reasonably necessary and not out of proportion to the threat. You also can't go one step further and cross the line into retaliation. The next defence, discipline, is of course very controversial. A parent, a school teacher, or the captain of a ship or aircraft may use force or cause force to be used in pursuit of their disciplinary powers, provided the force used is no more than reasonably necessary in the circumstances. So the force which might be used in relation to a young child by a parent might obviously be less than the force that might be used to stop a 16-year-old child from fleeing home in order to meet their drug dealer. The final defence is lawful authority. This has a couple of aspects. Most obviously, a police officer executing their powers of arrest or an authorised person detaining somebody under an involuntary treatment order for their mental health would have very specific legal powers to engage in conduct which, in the absence of those laws, would be assault, battery, or false imprisonment. Second, as you'll find when we look at interference with land and goods, certain torts allow people to engage in self-help. For instance, by entering premises to take back their own goods which are being withheld from them. In those circumstances, the person engaging in self-help will be entitled to use force, but not to such an extent that they cause grievous bodily harm. Okay, the next major category of tort for us to discuss is the category of interference with goods. You'll sometimes see this referred to as trespass to goods or trespass to chattels. Now, before we really start looking at the torts themselves, there are a couple of concepts that you need to wrap your head around. If you've already done property law, you'll probably know all of this, but the refresher is not going to kill you. There are two key types of relationship that a person might have with an object: ownership and possession. Now, very often they're the same. I own something and I have it in my possession and it's mine. But there are also lots of occasions when ownership and possession are separate. If I hire a car, I take possession of the car, but the rental company still owns it. If I lend you a book, then you're in possession of the book, but I still own it. It's very important, before we go any further, for you to have very clearly in your mind the distinction between ownership and possession. The second concept I want you to understand is what we call constructive possession. You see, Australia is an absurdly rich country, and many of us own an awful lot of stuff, far more than we could keep with us at all times. Constructive possession refers to things that we possess even if we don't have them immediately on hand. We possess them because any time we want to, we can go and grab them. And we can also decide whether anyone else is allowed to grab them. So when I leave for work in the morning, I'm still in possession of my TV at home because I can watch it whenever I like, and I can decide who else gets to watch it. With me so far? Now, the torts relating to interference with goods, they protect possession. So the person who was in possession of the goods at the time they were interfered with is the person who brings the action, not the owner. It fascinates me that this is still true even if the person is in wrongful possession of the goods. A person who's in wrongful possession can successfully sue in tort anyone except the rightful owner of the person, or a person acting with their authority. So let's say you loaned me your car and you said, Anthony, get it back by 8 p.m. Friday, please. But I didn't. Saturday afternoon, I still had the car, and someone else stole it from me from the shopping centre car park. Can you see that they've stolen that car from me, not from you? And if I caught them, they could hardly weasel their way out of it by saying, well, hang on, Anthony, you're not the owner of this car, and you're not supposed to be in possession of it, so you have no more right to the car than I do. No. These torts protect possession. So the first question we have to ask in relation to any tort to do with goods is, who was in possession prior to the tortious conduct? Let's have a look at the torts themselves. There are three key torts: trespass, conversion, and detenue. Trespass itself follows the form of words we've already come to expect. It's an intentional act which directly interferes with the plaintiff's possession of their chattel. To be honest though, you almost never see this particular tort relied on. Really, when we think about interference with goods, we're thinking about conversion and detenue. Conversion occurs when there is an intentional act which directly interferes with the plaintiff's possession of goods in such a fundamental way that it essentially excludes the plaintiff's possession. Now, this is a bit of a fuzzy definition in some ways, isn't it? It's not like the elements of the tort tell us what specific actions are going to constitute conversion. In fact, you can convert goods in any number of ways. The only real question is whether you've interfered with the goods in someone else's possession in a way that essentially excluded that possession. However, without defining or somehow limiting the types of conduct that can be conversion, we can at least identify some helpful categories. For instance, if the defendant took my goods and disposed of them by selling and delivering them, that would definitely be a conversion. It's completely inconsistent with my possession of those goods for them to be sold and delivered to someone else. Second, if someone takes goods in my possession and they take possession of those goods for themselves, well, that on its own is a conversion. I mean, they've excluded my possession. I can no longer say that I control who uses those goods and who does not. If they've excluded my possession, well, they've converted the goods. The third one's a bit more complicated. Imagine for a moment that I loaned an item to a friend, say a car. I loaned it, or as we say in the law, I bailed it to them, subject to certain conditions. For instance, it might have been a condition that the car was only going to be used for short trips in town. Now let's say that on the following day I saw an Instagram photo of my friend in my beautiful car screaming around hot drift laps on a local racing track. In this case, they've been given limited possession of the goods and they've abused those limitations. By doing that, they've also abused my possession of those goods because they're essentially denying me the chance to set limits around how others might use my possessions. Next, let's say I transferred possession of my car to a friend, that is, I loaned it to them, and they then loaned it to someone else. That's not okay, at least not unless they ask me first, because by transferring possession to someone else, yet again, they're denying me the right to control who's in possession of my goods. So that's a conversion too. One last one. If I've loaned something to you and I've loaned it to you at will, which means I can ask for it back at any time, well, that means you have to give it back when I ask for it. And if you don't, if you withhold my possession when I'm entitled to take it, then you guessed it, that's a conversion. You can see the common thread running through all of these. They all relate to situations where a person with the right to possession of goods is unable to exercise that right because some other person who either has no right of possession or only a limited right of possession is acting in a way that stops the plaintiff from enjoying their rights of possession. That's what conversion is all about. Now, debt anew is subtly different to conversion, but realistically there's still quite a bit of overlap. Debt anew is the intentional refusal by the tortfeasor to relinquish goods to the plaintiff, provided the plaintiff is entitled to possession and the plaintiff has demanded the goods. Let's break that down. The first element is that there must be goods. That's pretty obvious since we're talking here about torts that interfere with goods. The second element is that the plaintiff must be entitled to possession of those goods. Now that can happen in a number of ways. Perhaps I loaned the goods to you for a period of time and that period of time has expired. Perhaps I loaned the goods to you on the basis that I could get them back any time I wanted and I want them now. Perhaps I loaned the goods to you on the basis of a condition and you've broken the condition. Perhaps I didn't loan the goods to you at all and you've either accidentally or deliberately taken them from my possession. In any of these cases, I'm entitled to possession. If I wasn't entitled to possession, there could be no action in debt anew. Next, there has to be a demand. This is a bit different to conversion because there are many types of conversion where the cause of action is good to go without the plaintiff needing to actually ask for their goods back. With debt anew, however, the cause of action is not actually established until there's a demand for possession. The demand also has to be entirely clear and it has to provide sufficient details to enable the defendant to comply with it. So for instance, it has to indicate when and where the goods should be delivered, and those demands have to be reasonable. So if the plaintiff is entitled to possession and they've made a demand, well then the defendant should deliver up the goods. They are entitled to continue to detain the goods for a short time, just to ensure that the person making the demand is in fact entitled to the goods. But beyond that, they must deliver up the goods. If they intentionally refuse to do so, then an action in debt anew will succeed. So if debt anew and conversion are so similar, why do we still have debt anew? Well, debt anew allows for a slightly different type of remedy. We haven't really discussed remedies yet, and we're going to do that later. But for now, let's just say the usual remedy for conversion is the payment of damages. However, for debt anew, the court can also potentially order the delivery up of the specific goods. And when the goods are unique, like for instance an artwork, this could be very important. You don't just want the painting, you don't just want the money, you want the painting. The next interesting thing to know about conversion and debt anew is that if a person is entitled to immediate possession of goods, then they're actually entitled to go and obtain those goods. So you can enter someone else's land in a way that might ordinarily amount to trespass, provided you're doing so in order to obtain possession of goods belonging to you. You can even use reasonable force against the other party, if that force is reasonably necessary in order to recover possession. And the use of that force won't be an assault or a battery. However, in recent years it seems likely that this right might be read down so that it only applies if the goods were wrongfully taken in the first place. So you can use this right, which we call the right of recaption, if someone has stolen an item from you, but you couldn't use it if you'd, say, loaned it to them for a period of time, so that they'd been acting quite validly when they first took the item. This is probably sensible because in reality we don't really want people running around using force on one another over property disputes. Beyond this, the defences to these interference with goods torts are pretty similar to the ones we've already encountered when we looked at interference to the person. Consent is a pretty obvious one. Also necessity, so you can move or take possession of an item if this is necessary to protect the item itself or stop it doing damage to some person. Lawful authority is also very much the same for interference with persons. There's one additional defence I want to look at. It has a Latin name, ex turpi causa, which means there is no cause of action from dishonourable conduct. That means that if the plaintiff and the defendant were engaged in some sort of crime or tort together, and the goods were involved in that improper conduct, well then the law is not going to intervene to protect one wrongdoer from another. This leads to the curious situation where a defendant might actually need to prove that they themselves were involved in improper conduct in order to resist a tort claim against them. Our final tort related to trespass is known as trespass to land. It protects people against the intentional interference with the exclusive possession of their land. Now, as those of you who've done land law will already know, land is in some ways very similar to goods, yet in other ways entirely different. Both land and goods can be owned, obviously, and both land and goods can be in the possession of someone other than the owner. So, for instance, if you're renting a house, then you're in possession of that house, but the lessor retains ownership of the house. With land, however, there are additional layers, and it's really important to understand those layers in order to understand how tort law protects the possession of land. Because just like for goods, tort law protects possession and not ownership. So at the top level, we have the owner of the land. The starting position, of course, is that the owner can do what they like with their land, including possessing it. However, they can also give up possession to someone else on the basis of either a lease or a license. So the next level down is the lessee of the land. That's the person who's taken out a lease. Now, under our property law, they actually have what we call an estate in the land. So they're not just a borrower, they have an actual leasehold right which they can insist on, even in the face of the owner. The next level down is what we call a licensee on the land. A licensee is someone who's been allowed onto the land by whoever's in possession of the land. Now, there are two types of licensees. The first type, which we'll call a substantial licensee, is someone who has either an ongoing license to be there, so say someone who's temporarily renting a room but who's not on the lease, or a person who has ongoing permission to come to the yard and take mangoes from a mango tree in the yard. So you can see they have a kind of possession, but it's limited, either in time or scope. The second type of licensee we'll call a mere licensee. They're on the land as a result of permission from whoever's in possession, but really all they have is permission to be there. So someone who comes over for a drink is a mere licensee. Someone who walks through your yard to knock on the door and offer you a pamphlet is a mere licensee. Finally, at the bottom of the heap we have squatters, who might be in possession of the land or some part of it, but their rights are really quite limited. So who among these has an interest in land which can be trespassed upon? Well, the owner does, but only if they've retained possession. If they give up possession, for instance by granting a lease, then they no longer have an interest that can be trespassed upon. The person in possession, in this case the lessee, well, they definitely have interests which can be trespassed upon. So they will be the usual plaintiff in trespass to land actions. What about a substantial licensee? Well, a substantial licensee might actually have an interest that can be trespassed upon, but their interest would be limited by their license. What do I mean by that? Well, if they're staying in a room, it's reasonable for them to think that others won't trespass on their room. If they're going on the land in order to pick the mangoes, it's reasonable to think nobody's going to take steps to prevent them from getting to the tree. But beyond the terms of their license, they have no interest to protect. And if the license can be withdrawn at the whim of whoever granted it, well then it offers no protection at all. A mere licensee has no interest to protect because they have only the most tenuous connection to the land. Strangely though, squatters do in fact have sufficient possession to form the basis of a trespass action, but only against any later trespasser. So they can't maintain an action in trespass against anyone who has lawful possession of the land. But if they'd set up a tent down by the river on a block of land, someone else's land, well, someone else can't come along and occupy that tent and say, tough biggies, you're only a squatter. So there is a basis of action there, but it's pretty limited. Finally, I need to make it clear that while I've tried to give those thoughts some structure, the bottom line remains that possession is always a question of fact, and ultimately, whether a plaintiff is in possession or not will be a matter for the courts to decide. Okay, so now we have a sense of who can sue. The next thing we need to think about is what we actually mean by land. I mean, at its narrowest, land might only mean the very top millimetre of dirt within the boundaries. You could say anything above that is sky and anything below that is underground. At its broadest though, land can be a column stretching from the core of the earth out into space. There was an old Latin legal phrase meaning whoever owns the land owns that land all the way from hell below to heaven above. So what are the actual rules? Well, let's start with the sky. The general principle is that a trespass has to actually interfere with your rights of exclusive possession. And so in each specific set of circumstances, there's going to be a height above which anything that really happens doesn't actually interfere with your rights. I mean, there are websites out there that will let you track the International Space Station's orbit around the Earth. And if it goes right over my house, it's pretty hard for me to suggest that's a trespass, isn't it? By the same token, in one of the famous cases, flying an aircraft hundreds of feet over a house was no trespass. But as you get closer to the ground, things get more complicated. I mean, I imagine that a drone 30 or 40 metres in the sky hovering over my backyard might constitute a trespass, as well as breaching aviation laws. In one case, a building crane 20 metres off the ground was held to be a trespass when it passed over the plaintiff's land and caused her anxiety. So really, how high up the land goes depends very much on the circumstances. Does the alleged trespass really interfere with your exclusive possession of the land? The same general principle applies on the way downwards. If you're in possession of the land, well, you're perfectly entitled to dig a hole. You generally don't have the rights to any mineral deposits beneath your land, but a trespass underneath the land might be caused, for instance, by a neighbour whose excavations led to erosion or undermining of your foundations. Because you can see that this has a genuine impact on your ability to exercise your possession of the land. So now we know whose interests are protected by the tort of trespass to land, and we know what we actually mean by land. Finally, what sorts of things can be a trespass? Well, the most obvious one is coming onto the land. I mean, that's a trespass. A second obvious one is staying on the land when you've been asked to leave. This happens a lot in places like shopping centres where teenagers who are known to be problematic might be asked by centre management to leave, or at licensed premises where the bouncers will politely ask you to leave and then, if necessary, somewhat less politely, escort you out. But there are other types of trespass. For instance, if you place any object on another person's land, well, that's a trespass. If you place objects in a way which will later result in them going onto another person's land, well, that's a trespass too. So, for instance, if you rake up your leaves and leave them in a big pile on the fence line, knowing that the wind will blow them all next door, that's going to be a trespass. The other thing to know is that even the merest trespass is enough. Trespass cases have succeeded, even when the incursion was a matter of mere inches. So what about defences then? Consent, necessity, lawful authority, they're all defences we've come across previously and they work here as well. There are a number of ways in which we imply consent, even when it's not explicit. For instance, if we park our car across the footpath, there's an implied consent that people can walk around the front to get past, even if that means coming onto our land. Necessity, again, is all about actions necessary to protect life or property. So, for instance, trespassing on someone's property to help put out a house fire is not a trespass. But there are some other interesting ones regarding land. We've already spoken about the fact that it's lawful to enter premises in order to retake goods where we're entitled to immediate possession of those goods. A person in possession of land also has the right of ejectment. That is, they can use reasonable force to remove people or goods from their property. In the case of people, they have to be asked to leave and given a reasonable opportunity to do so. But after that, the right of ejectment allows the use of force, even when that might ordinarily be a trespass to person or a trespass to goods. Be careful though, because in Queensland and a number of other states, that right of ejectment is not present if that person has a claim of right. So in other words, if they claim the right to remain on the premises, even if they're wrong, then ejectment might not be possible. So as a practical matter, honestly, give the cops a call. Alright, that brings us to the end of our discussion of the types of tort derived from the concept of trespass. Trespass to persons, trespass to goods, trespass to land. Now we're going to start looking at some of the other types of intentional tort. These tend to be a little more distinct from one another, but they still all do really hang on the same idea as trespass. That people have certain interests and they should be able to enjoy those interests without the interference of others. So the next interest we're going to look at is the interest we have in our own reputation, which is protected by the tort of defamation. Defamation occurs when a tortfeasor publishes to a third party, by any means, some material which, when read by a reasonable person, would expose the victim to disparagement, hatred, ridicule, or contempt from that reasonable person, or which would cause a reasonable person to shun them. So there are really three elements. First, has there been publication? Now, publication is a problematic word in this context because it kind of gives the idea that we're talking about putting something in a formal publication. But publication here means to make public. So saying something to the defamed person directly is not publication. But the moment you say it or communicate it by any means to anyone else, there is publication. To make matters slightly more complicated, republication is the same as publication, but the original publisher becomes responsible for all those republications. So if I write something in an email to a third party defaming my victim, but then that third party republishes my letter in a book about the victim, I'm potentially liable for all the harm done by my letter, including when it was republished. The second element is, can we identify the fact that the plaintiff is the one described by those words? Now, often that won't be altogether difficult. However, in many cases, the tortfeasor, trying to be clever, will not use the name of the victim, but rather they'll leave it to innuendo. In other circumstances, the publisher might refer to a category of people rather than referring to an individual. It'll be up to the person bringing the case to demonstrate to the court that they personally have been defamed by the publication. Now, they can't bring that action on behalf of a group or a class. Merely being a member of an impugned group is not enough. Similarly, most corporations can't bring defamation proceedings. Finally, as most people know from popular culture, you can't defame the dead. So ultimately, the plaintiff as an individual is going to need to show that they as an individual have been impugned by the words which were published. The third and final element asks whether the words complained of carry a defamatory meaning, which we call a defamatory imputation. So do they disparage the victim? Do they bring about hatred, ridicule, or contempt from a reasonable reader, viewer, or listener? Would those words cause the reasonable person to shun the victim? Now, back in the day, defamation law consisted of two common law causes of action, called slander, where the words were in transient form, such as words spoken, and libel, where the words were printed or recorded in more permanent form. It also used to be the case that the defences to defamation varied from state to state. Now, even before the internet became all-encompassing, it was clear that in a world of national newspapers and national broadcasters, it made no sense for defamatory publication to be unlawful in one state but potentially allowable in another. So in 2004, after a quite exhaustive process, the states and territories agreed to essentially uniform defamation laws, which were passed in 2005 and which now give us the same defamation laws right around Australia. Now, I don't have time to be getting too theoretical in a 2-hour video, but you have to understand that there's a conceptual challenge at the very heart of defamation law. You see, defamation law occurs at the intersection of two very important principles. On the one hand, we have the principle that people's reputations should be protected against improper attacks. And that sounds fair enough too. Yet on the other hand, as a society, we also value the principle of free speech, particularly when it comes to public affairs. And these principles are fundamentally opposed. The more your reputation is protected, the more boundaries there are on my free speech. The more of my speech is free, the less your reputation is protected. The eternal question for the courts, the parliaments, and our community as a whole is how we undertake this balancing act. It's particularly important when it comes to the media. The threat of a defamation action, which may tie up staff for months and cost many thousands of dollars in legal fees, may be an effective means of suppressing unwelcome media attention. The news website crikey.com.au has for some years maintained a list of Australian politicians who've commenced defamation proceedings primarily against media outlets, and it's surprising how many of those end up settling out of court. One of the ways in which the uniform defamation legislation tries to manage this balance between free speech and the protection of reputations is by setting in place a number of defences to defamation proceedings. Now, oftentimes in defamation matters, establishing the cause of action itself is not all that difficult. Not too hard to identify the plaintiff or to find the words which have a defamatory imputation. Often then, the real battleground is whether one of the defences applies. Now, there are a bunch of them, and I'd suggest you go have a look in the Defamation Act to read them in detail. But let's look at some of the key ones. Two of the defences relate to truth. It's a defence if the allegedly defamatory statement is substantially true. It's also a defence if the defamatory statement is what we call contextually true. This is where there are some statements shown to be true and others not true. But the statements which are shown to be true have done so much damage to the plaintiff's reputation that the untrue statements don't make things any worse. The interesting thing about these defences is that it means if something is true, it can be safely published, no matter how intrusive it is, no matter how much it might be in bad taste, and no matter what amount of harm is going to be caused to the subject. So this is one instance in which the balance has tipped in favour of free speech. Second, it's a defence to defamation if the publisher is genuinely reporting on the proceedings of public bodies, which by their nature we expect to be open and fair. So there's no danger in publishing words spoken under the privileged immunity of Parliament or court. And there's no danger in publishing public documents. And there's no danger in giving a fair report of proceedings of public interest based on a formal report of those proceedings. Third, there is a defence referred to as the defence of honest opinion. Now, this one's a bit tricky. It is a defence to defamation if the publisher is publishing their honest opinion about a matter of public interest and if the opinion is based on proper material, which essentially means on true material. So there are three elements here. First, the opinion has to be honestly held. So if you're a food critic and you give a bad review to a restaurant when you actually like the restaurant but you know that bad reviews attract more clicks, well, you couldn't rely on this defence. Second, the opinion has to be about a matter of public interest. Now that's actually pretty broadly defined by the courts. Anything which isn't truly a private matter will likely be considered to be of public interest. Third, the opinion has to be based on proper material. So if the opinion turns out to be based on material which is itself defamatory, well, it makes sense that the opinion would be defamatory too. In this defence, I think you can really see the Parliament trying hard to balance free speech and the protection of reputations. You can express whatever opinion you like, but it has to be your honest opinion. It can't be about truly private matters, and it has to be based on proper material. Okay, the last one I want to talk about is called qualified privilege. This one is basically the journalist's friend. It says that you have a defence if you're providing a report to a recipient who has an interest in the topic, and if you behave reasonably in all the circumstances, which means things like doing your best to check the accuracy of statements, acting from a sense of public duty and not a sense of malice, and whether the person making the report tried to give the other side an opportunity to put their view. Okay, before we move on from defamation, I want to make one last point, and that is that nowadays roughly half of all defamation cases relate to online publications. And with the advent of modern social media, a single post by a single person might suddenly go viral and be reposted and viewed potentially millions of times, potentially right around the world. At the same time, social media has transformed the internet from being the information superhighway to being the opinion superhighway, where people feel they have the right to promote whatever opinions they might hold, regardless of the validity of the foundation of those opinions. Don't be fooled. Publication on the internet and publication on social media is still publication, and it still puts you at legal risk. I cringe when I see these memes going around with someone's photo saying, "Be on the lookout, they're a pedophile." Now, these are shared by good people trying to do the right thing. But what if the photo's wrong? We're going to turn now to an entirely different family of torts. With all the torts we've discussed so far, the interest which is protected is fairly uncontroversial. Within our culture, it seems entirely normal for the law to protect a person's body, their possessions, their land, and their reputation. Economic interests, however, are a bit more fuzzy for a couple of reasons. First up, nobody has the right to a particular economic outcome. Sometimes investments go well, and sometimes they go disastrously. Sometimes a competitor might do extremely well because they had a really pithy commercial, even though their product is inferior. Economics just isn't always fair. Second, economics is inherently competitive. If I'm selling books and you're selling books, then I want people to be buying my books, and I don't want them buying yours. I'm trying to out-advertise you, I'm going to try and beat you on price, I'm going to try and beat you on quality. Everything I do to try and ensure my own economic success will also be in part an attempt to suppress your economic success. It's harsh, but that's business. So we could hardly have tort law which penalised me for harming you. We have an economic system that rewards people for harming one another. But there are limits, aren't there? Our economic system is not going to reward me if I go around and burn your shop down. Ideally, we do want economic competition, but we want it to be conducted fairly. So this category of torts, torts interfering with economic interests, regulates behaviours which constitute unfair forms of economic activity. The first three that I want to talk about all relate to dishonesty. We call them injurious falsehood, deceit, and passing off. Then we'll talk about three torts where the tortfeasor is acting with a bully's aggression, interference with contracts, intimidation, and conspiracy. The first one, injurious falsehood, is sort of a second cousin to defamation. It doesn't protect reputation, but rather it protects the ability to trade. Injurious falsehood happens when the tortfeasor spreads information about the victim or the victim's goods in an effort to stop people from dealing with the victim. The tort is only complete when it actually has that effect. So if a restaurateur started telling people on Facebook, "The health inspectors have been spending a lot of time looking at my competitor's restaurant lately," and if that was not true, and if people stopped going to dine with the competitor as a result, well, the competitor might sue for that lost trade due to the injurious falsehood. Our second dishonesty tort is called deceit. This happens when the tortfeasor makes a false statement of fact, and they either know the statement is false or they don't care whether it's true or false, and where they make that statement with the intention that the victim will rely on the statement. If the victim does rely on the statement and they suffer a loss as a result, well, then they may be able to claim a remedy in the tort of deceit. The classic example is the case of Peake and Gurney, where there were false statements made in a company prospectus, and that deliberately misled potential investors about the liabilities associated with a company takeover. Now, any investor who had invested in reliance on those statements would have been able to sue in the tort of deceit when the whole venture failed. Our final dishonesty tort is called passing off. Now, the beautiful kingdom of Cambodia is one of my favourite places in the world. And from time to time, I've visited the Aussie market or the Russian market, and I've picked up a great pair of Ray-Ban Sunnies for $5 or a Hugo Boss shirt for $7.50. Now, either I'm the best shopper in the world, or those are two great examples of passing off. You see, passing off occurs when a merchant makes misrepresentations to potential customers, and where those misrepresentations are calculated to injure the trading activities of a competitor, and where they actually do cause that injury. So by selling me $5 fake Ray-Bans, the market stall holder was basically depriving the real Ray-Ban company the chance to have me as a customer. Unless, of course, they were the real deal. Similarly, a business which adopted a trading name very similar to its competitor might be sued for passing off. A business that adopted a colour scheme or a logo or a distinctive packaging too similar to its opponents might be sued the same way. The damage is not just the loss of business by the victim's company, but also the potential harm to their reputation and goodwill if their logo and their business name, instead of being associated with high quality products, is attached to inferior products. Okay, the other three economic torts I want to discuss are really quite a bit nastier and more aggressive. They're not just dishonest, they're genuinely mean. The first one is called interference with the performance of a contract. So let's say that you're aware that your business competitor has scored a lucrative contract and you're upset about it. There are some things you can do. You can try to undercut them on price, for instance, and make an even better one than they've contracted for. Well, that's fine. That's just competition. But there are things you can't do. Specifically, you couldn't try to bribe one of the parties of the contract into breaching the contract. And you can't take other steps that are calculated to prevent the parties from discharging their obligations under the contract. A great example of this happened in the World Series cricket case in 1978. For those of you who don't follow cricket, Australia's Kerry Packer was intent on establishing a rival system of international cricket, and he'd signed contracts with 36 of the best players in the world to play in his matches. The English cricket authorities swiftly made a new rule which meant that any player who honoured their contract with Mr. Packer would not be allowed to play official matches in any other competition. Now, this action by English cricket was found to be an intentional interference with the contracts between Mr. Packer and the cricketers, intended to procure the breach of those contracts by the cricketers. The second of our nasty torts is called intimidation. Intimidation occurs when a party threatens their victim or someone connected to the victim with some form of unlawful act if the victim doesn't take certain steps which will result in them suffering economic loss. This tort has long been associated with union activities in the UK and in Australia, where the line between legitimate industrial action and unlawful intimidation is often very difficult to discern. The foundation case in Australia, Sid Ross and Actors and Announcers Equity, involved the threat of unlawful picket lines against certain clubs if they continued to deal with Mr. Ross. They stopped dealing with him, and of course his business suffered. Unlawful intimidation, whether in the industrial relations context or any other context, may result in the victim being able to sue the intimidator to recover any economic losses they suffered in compliance with the intimidation. Our final economic tort is referred to as conspiracy. It's fairly similar to the concept of conspiracy you may have already come across in criminal law. It occurs when two or more parties engage in a joint design to commit unlawful acts or lawful acts in unlawful ways in order to cause harm to a victim. Now, if they do so and they're successful in causing harm to the victim, well, then the victim may have an action to recover any such economic harm. Again, conspiracy has led to a fine line being walked between legitimate industrial action and unlawful conspiracy. The foundation case in Australia, McKernan and Fraser, was one in which members of the Seamen's Union conspired to prevent the plaintiffs from being engaged by any vessel until they paid their union dues. You can see how it really is a matter of one's personal political views, whether this was an example of legitimate union solidarity or quite offensive conspiracy and intimidation. Next, we're going to look briefly at some torts which in some ways feel like we're stepping into a time machine and going back into the antique past, back into the days when the patriarchal nature of our society was unchallenged and where people had servants and slaves. You see, there's a range of torts whereby people seek to be compensated for harm that's been done not to them personally, but to the people they rely on, personally or economically. There are four categories: interference with a person's provider, their employee, their spouse, or their children. Now, before we actually get underway, it's important that you understand this is an area of tort law which has been heavily amended over the years by statute, and the statute's worn off some of the worst of the sharp edges. If you're watching this video in a state other than Queensland, it's important that you carefully check where the law stands in your state. We're going to start by thinking about the loss of a provider. For years and years, tort law was in a somewhat counterintuitive position where if a person was injured, say by a battery, they'd be able to sue in battery and obtain compensation. However, if they were killed, well, obviously it'd be a matter of criminal law, but the position of tort law was that they were now deceased, so they couldn't maintain an action, and they no longer had interests which could be protected by tort law because they were dead. Now, while that sounds odd, there is a certain logic to it. But what about any dependents of that deceased person? If a person has a dependent spouse and two dependent children, and I run them down with my car and kill them, well, haven't I also harmed the interests of those dependents? I mean, they're now left high and dry, aren't they? This was particularly the case prior to compulsory superannuation with its death benefits, but even in that case, dependents might be left high and dry. As a result, the Parliament has passed legislation enabling dependents, which usually means spouse and children, to claim compensation for the death of a provider. In addition, claims can be made for the value of gratuitous domestic services provided by the deceased person, which means, in effect, if the deceased person was not in paid employment, but if they were, say, a carer, then the value of their contribution can also be compensated. Naturally, of course, a marriage or partnership is not merely an economic venture, and the harm done to a person by the injury or death of their spouse goes well beyond the loss of earning capacity or their domestic services. Spouses offer one another companionship, love, sexual partnership, and the concept of a mutual future. These things are all much harder to quantify, but they really are the essence of the relationship. And the statutes recognise this by allowing an award of damages for what's called loss of consortium. This is only allowed if the spouse dies or if they suffer very serious injuries. Lesser or more transient injuries will not support a claim for temporary loss of consortium. Note, however, that this remedy is only available in Queensland and South Australia. The other jurisdictions in Australia have all repealed the loss of consortium as a cause of action. All right, now let's really go through the historical looking glass. In relation to children, there used to be torts called seduction, whereby if any man other than her husband had sex with an adult daughter, that man would be liable to her father for her supposed loss of value. And there used to be a tort called enticement, if a tortfeasor enticed a child to move away from their parents. And there used to be a tort for the loss of services provided by an injured child. All three of these, believe it or not, remain on the books in Queensland. And they remain on the books in a number of other states, but they haven't been relied on in many years. And in truth, if a party did seek to rely on them, the court would most likely find that they were no longer the law. Finally, and perhaps a little more sensibly, an employer who loses the services of an employee as a result of someone else's tort can sue for the losses they incur as a result. We call this an action for the loss of servitium. Now, in many cases, of course, the employer is hardly going to find it worth their while to pursue this action. They'll generally just hire a new staff member and get on with it. However, if the employee had particular value, let's say they had a unique public image and so now the whole advertising strategy needs to be reconsidered, then it's easy to see why the employer might want to recover the losses arising from the tortfeasor's conduct towards their employee. Note, however, this is only available in relation to employees, not contractors or partners or anyone in similar business relationships. Finally, in Queensland, damages for the loss of servitium are only available where the damages claim reaches a certain statutory threshold. Okay, now we're going to change pace completely and talk about the tort of nuisance. So far, all of the torts that we've talked about have really relied on the basic idea that you have one person, the tortfeasor, and they do something wrong towards the other person, or the victim, or to their goods, their land, and this gives rise to the opportunity for the victim to sue them for damages. Nuisance is a bit different. Nuisance relies on the idea that we all live in a common environment. We live in a society, we live in a place, and the things we do, even in our own private environment, can have an impact on others. Under certain circumstances, if the things we do have a sufficiently negative impact on others, tort law will step in and either tell us to stop or to make good any harm we've caused to those around us. So there's no requirement for any direct improper behaviour towards another person or their goods or their land. The improper behaviour comes from creating circumstances by acting unreasonably or improperly in the environment. There are two types of nuisance: private nuisance and public nuisance. Private nuisance occurs when the tortfeasor unreasonably interferes with the plaintiff's ordinary enjoyment or use of their land. So it's related in a way to trespass to land, but it recognises that you don't always need to physically trespass in order to affect someone else. Now, there are no specific categories of what sorts of activities might constitute a private nuisance. In a British case called Hunter and Canary Wharf, Lord Gough of Chieveley gave a non-exhaustive list as follows. He said, noise, dirt, fumes, noxious smell, vibrations and such like. He said occasionally activities on the defendant's land are themselves so offensive to neighbours as to constitute an actionable nuisance, as in a case where the sight of prostitutes and their clients entering and leaving a neighbourhood premises was held to fall into that category. So given that there's no limit of the capacity of human beings to find new ways to be a nuisance, the question of a nuisance will turn on the individual facts of each case. However, we do know certain types of conduct which will not be considered nuisance, even if they do interfere with someone else's enjoyment of their land. First up, there's the general principle of live and let live. Anyone who's just behaving in accordance with normal standards of social conduct will not be committing a nuisance. So for instance, if I bang pieces of wood with a hammer at midnight on the closest boundary point to your house for no purpose other than maliciously disturbing you, well, that's a nuisance. But if I make exactly the same sounds in the course of doing some carpentry during the daytime, it's not a nuisance. A certain amount of neighbourly tolerance is expected. Next, the plaintiff can't rely on any special sensitivity they have. The test is one of reasonableness, so it's a matter of what a reasonable person might consider to be improper. This was famously stated by Vice-Chancellor Knight Bruce in Walter and Self, when he said the inconvenience must be more than one of mere delicacy or fastidiousness, not merely according to elegant or dainty modes and means and habits of living, but according to plain and sober and simple notions. Having said that, if someone knows you have a particular sensitivity and they maliciously take advantage of that to create a nuisance, well, that might be actionable even if the activity was relatively normal. Finally, there are two interesting issues regarding vision. First, a person has no actual right to a view from their property. So if someone else builds you out, then that's not a nuisance, even though they might be preventing you from enjoying the view you once had. Similarly, it's not a nuisance for somebody outside your land to look into your land, and for that matter, it's not a trespass for them to take photographs. Public nuisance is just a little different from private nuisance. If you think about the description of private nuisance which I've given, we're still really all about protecting private rights, aren't we? The value of the land, my view, my peace and enjoyment, my ability to go about life undisturbed. And you have to be the one in possession of that land in order to take action. Well, public nuisance extends this concept considerably. Public nuisance refers to nuisance behaviour which affects the public at large. And so it's generally the state that sues for public nuisance. And all states and territories also have a criminal offence of public nuisance. So what sorts of things can be a nuisance? Well, anything that obstructs public access to the roadways can certainly be a nuisance. Any sort of pollution activity that interferes with, say, the use of a beach or a lake or a park would be a nuisance. Attracting a crowd to a particular place and therefore obstructing people's passage through that place could be a nuisance. That's why most governments require permits for public rallies and the like. Do you get the picture? It's really the same sort of behaviour as private nuisance, but it affects the use of public spaces rather than private ones. The next thing we want to talk about in terms of nuisance is the actual parties. Now, in many cases, this presents little difficulty. The person creating the nuisance is obviously going to be the defendant, and the person whose land is affected will be the plaintiff in private nuisance, and generally the state will be the plaintiff in public nuisance. Sometimes a private person or company can be the plaintiff in public nuisance, but only if they can show they've been unusually affected by the nuisance. There are two more interesting questions though. First up, what if you buy a piece of land and then you discover that your predecessor in title has things set up in such a way that they create a nuisance for your neighbour? Well, it all depends on your state of knowledge. If you as the successor in title become aware of a nuisance, or if you're constructively aware, which means you could have become aware if you bothered to check, then you're obliged to take reasonable steps to remove the nuisance. However, if the nuisance comes from some cause where the successor in title really can't be aware, well then they're not going to be held liable. What about the other end of the equation? What if there was already a nuisance and someone comes along and buys a piece of land well aware of that nuisance? I mean, the classic example here is someone who buys a piece of land cheaply under an airport flight path and then whinges about aircraft noise. Well, one of the most famous cases of British law was a case called Miller and Jackson, and it starts with Lord Denning saying, "In summertime, village cricket is the delight of everyone. Nearly every village has its own cricket field where the young men play and the old men watch." Well, Lord Denning refused to award a remedy to a lady who had bought a home adjoining the village cricket field and who lived in terror of cricket balls. However, the general rule is that it is no defence to say that someone has come knowingly to the nuisance. If there is a nuisance, it must be abated, whether the plaintiff is new or not. There are, however, some successful defences which can be raised in response to an allegation of nuisance. First, consent and necessity, our old favourite defences, they still work for private nuisance. If the other party has consented to the nuisance, or if the nuisance was created to avoid some imminent peril, then there's a defence. Be careful though about consent. We've just learned that if someone comes to the nuisance, they can take action. And this is true even if their predecessor consented to the nuisance. Next, if there was an act of God that led to the creation of the nuisance, something that was catastrophic and couldn't have been predicted, then that will be a defence. So you might have to maintain sufficient drains to deal with normal rainfall without diverting the water into your neighbour's place. But if there's an extraordinary deluge, well, you won't be liable. Third, if the nuisance was created by some third party and the defendant didn't know and they couldn't have reasonably been expected to know of the nuisance, then they won't be liable. As soon as they do know, however, they have only a reasonable amount of time in which to take steps to abate the nuisance. Finally, if the defendant has some specific right or prescription or requirement under law to do the thing that is said to constitute the nuisance, well then that of course will be a full defence, provided the thing done actually does fall strictly within that authorising law. In the same way, there are now often specific laws regulating behaviour which might previously have been a nuisance. Aircraft noise, which I mentioned a few moments ago, is one of those. Okay, we've now really dealt with all of the torts that I've been planning to look at in this 2-hour overview. And we're doing pretty well for time too. However, before we move to the end of the program, there are a few other tricky bits and pieces I want to go through. Things that can affect all of the torts we've discussed above. So, vicarious liability and multiple tortfeasors. But before we even get to those, I want to take a couple of moments to talk about animals and children, because these often seem to come up in exams and the like. See, everything that we've talked about so far has really looked at the actions of a person, and sometimes at the way those actions have affected things or land. In the case of animals and children, though, we have a situation where there may be a tort involving something with a mind of its own, but for which an adult might be responsible. Let's start with animals. First up, there's a type of tort known as scienter liability. Scienter is a Latin word meaning to know. Scienter liability makes the keeper of an animal liable for any harm the animal might cause if one of two circumstances is true. First, if the animal is a wild animal. So if you keep a wild animal and it harms someone, well, then you'll be liable. Second, if the animal is a domesticated animal, but it has vicious characteristics towards humans, and you as the keeper know of those characteristics, well, then you will be liable if it harms someone. See where the scienter bit comes in? Now, scienter liability still exists in Queensland, but it's been done away with in a number of other jurisdictions, so please check your local laws. So keeping wild animals or animals with a vicious streak requires a lot of care. Next, there are some very specific rules in each state and territory regarding dogs. All states make dog owners, or those in charge of a dog, strictly liable for any harm the dog might do. That means it doesn't matter whether you intended to allow the dog to do harm or not. The wording varies from state to state. In Queensland, the rule is that it's an offence if you don't take reasonable steps to ensure that a dog does not attack or cause fear to a person. Now that's an interesting situation, isn't it? Who's been out for a run or a ride or in the park and suddenly an off-leash dog being walked by one of those idiots who doesn't want to obey the rules comes rushing at you? The owner happily sings out, "Don't worry, he won't hurt you," but by that time you're already looking for a tree to climb. Well, whether the dog attacks or not, the offence has already been committed. There are exceptions, of course, for dogs like police dogs, whose very business is to be mean and scary. But setting aside those exceptions, someone who's in control of a dog needs to stop that dog from causing harm or fear. There are also, in each state and territory, specific rules for breeds of dog which have been declared dangerous, and also for individual dogs which have been declared to be dangerous. Let's now think about children. As in other parts of the law, children occupy a really weird, ambiguous position because they don't have full legal personality, but they're still subject to the law. So the rules are often inconsistent and a little bit strange. Most of the torts we've discussed in this lecture have required either intention or recklessness in relation to an act. They haven't usually required intention of a particular harm, just intention of the act. And so if a child is able to understand the act that causes a tort, even if they're not able to understand the gravity of the harm they might be causing, well, they're liable. So the test is whether the minor was sufficiently able to form the intention of conducting whatever act caused the harm. This is a dumb rule, because surely the nature of the tort relates ultimately to the harm. If a child does something and it never occurs to them that their action might hurt anyone, well, how do we say that they start in the same position as an adult? Now, lots of people believe that parents are responsible for their children's liabilities in tort. That's not actually so. And that's one of the reasons that so few people sue children in tort. It's much more likely that an injured person will just sue the parents or whoever was in charge of the child for negligence. The bottom line, though, is that a child can be liable in tort. We're going to turn now to a mind-bending little concept called vicarious liability. Vicarious liability is a situation where one person or entity can be responsible for torts committed by others. In practice, this overwhelmingly occurs when an employer is held to be vicariously liable for the actions of an employee. And it makes sense for this to be the case. I mean, imagine, for instance, a crane operator on a big building site. That operator might not be making an awful lot of money, just a working person doing their job. But the equipment they're lifting might be worth millions of dollars. If they were personally at risk for any harm to those goods, well, who'd take the job? Realistically, it's employers that carry the insurance for such things, and employers who make the contract with the client, and therefore it's employers who bear the liability, either alone or jointly with the employee. But especially in these days of the gig economy, how do we know when someone's actually an employee? I mean, it's become pretty common for companies to insist that people filling staff roles within their organisation should actually become contractors. The court hasn't actually set out a single test to determine whether somebody is an employee or a contractor. However, the court will look at factors such as the extent to which the employee's activities are controlled by the employer, the extent to which the employee's activities are integrated into the business system of the employer, and the extent to which the employee would be considered by others as representing the employer. The more that it seems a person is integrated in the business activities or subject to the control of the employer or representing the employer, the more likely it is that they will be considered an employee for the purposes of vicarious liability, regardless of how the employer and employee themselves characterise their relationship. Okay, let's assume there is an employer-employee relationship. That's not yet enough for vicarious liability. Next, we need to establish that the tort has happened in the course of employment. So whatever action constituted the tort, that had to happen in the course of employment. This can be a tricky concept because not everything you do at work is regarded as being done in the course of employment. You might do something at work which is completely unrelated to your employment. So a bar worker who threw a glass into a customer's face, ultimately causing him to lose an eye, was considered not to be acting in the course of her employment. At the same time though, just because an employee is not following all the rules doesn't mean they're acting outside the course of their employment. So for instance, a person who fails to follow a safety procedure resulting in harm to another person is still acting within the course of their employment. Finally, before moving on from vicarious liability, it's important to point out that because vicarious liability happens in the course of employment, it very often happens in the workplace. And we now have comprehensive nationwide workplace health and safety laws, which also provide for the responsibility of employers and employees for the safety of others in their workplace. So often you won't be looking to tort law at all. Okay, in all of our discussions to this point, with the exception of the economic tort of conspiracy, we've pretty much assumed that there was one tortfeasor causing the harm. In the real world, however, it's often not like that. If there's more than one person involved in committing a harm, we need a way for the victim to be able to take action against all of them. And we also need a way to divide up the liability between them. We split these multiple tortfeasor situations into two types: joint tortfeasors and several tortfeasors. Let's look at each of those now. Joint tortfeasors are in on it together. They've basically formed a team to carry out whatever conduct formed the tort. I mean, we've just been talking about one obvious form of joint liability, and that's vicarious liability. If you have an employer and an employee and conduct which occurred in the employment, well, they're all pretty clearly on the same team, aren't they? We've also run into another good example. Remember Mearing and Graham White Aviation? That's the one where the boss was interviewing an employee in a locked room with the goon squad outside to prevent him from escaping. Now you can see there that they were all acting as a team. They had a plan, they executed it. So even setting aside the fact that they were employees, they were joint tortfeasors because they were all part of the team committing the same tort. Now, even though there's more than one tortfeasor, each tortfeasor is responsible initially for the whole harm and the whole remedy. So you can't just say, well, there were four of us, so I'm only paying a quarter. So you want to make sure you choose your conspirators carefully, hopefully rich ones. However, with joint tortfeasors, once one party has paid the remedy, the liability of all parties is extinguished. So everybody's liable for the whole amount, but once that amount has been paid by someone, everybody's liability is discharged. Now we say that there have been several tortfeasors when the actions of two or more tortfeasors have combined to cause the harm, but where they haven't been part of the same team and there hasn't been any joint plan between them. The classic case called the Kursk is a great example. 5 ships, including the Itria, the Clan Chisholm and the Kursk, were all sailing in a convoy, and they were line abreast, so side by side. The Itria in the middle was the guide vessel. Clan Chisholm was next to her, and the Kursk was on the other side of Clan Chisholm. Now the Kursk negligently came off course, and it was threatening to collide with Clan Chisholm. Clan Chisholm started taking evasive manoeuvres, but didn't do what she should have done, which was to reverse her engines and get out of the way. As a result, the Corsk ran into the clan Chisholm and pushed the clan Chisholm into Itria. You can see that both Corsk and clan Chisholm were at fault for the harm to Itria. Corsk should have stayed on course. Clan Chisholm should have reversed her engines. But there's no sense in which they were part of some collective plan to run into Itria. They made separate mistakes which contributed to the single tort. That makes them several tortfeasors. Now, where there are several tortfeasors, the tortfeasors are not each responsible for the whole of the harm. The court can apportion responsibility between them. Each of them will then be responsible for a proportion of the remedy equal to their proportion of the liability. One last thing about multiple tortfeasors. Sometimes the plaintiff might only sue one tortfeasor, but that tortfeasor might consider that others were also responsible for the tort. Or alternatively, there might be a judgment against joint tortfeasors, but then they sit around looking at one another waiting to see who's going to pay. In either of these cases, a person who is liable for a judgment or settlement in tort can sue for a contribution by any other party who would also have been found liable had they been sued. So this includes joint tortfeasors who actually did get sued and parties who perhaps should have been sued but weren't. The court will then apportion the remedy between the contributors based on the court's view about the level of responsibility which each party should accept, based on their conduct in committing the tort. All right, now all of a sudden we come to the last substantive section of our 2-hour intentional torts course. We're going to finish by talking about remedies. About time, some of you will be saying. I mean, it's kind of odd in one sense, isn't it, that I've talked about all these different torts without really talking about remedies. We have talked about the self-help remedies that are available. So in a debt anew situation, you're allowed to trespass on premises and use reasonable force to get your stuff back. And in a trespass to land situation, you're allowed to use reasonable force to enter your own land and to eject people and things which are on your land and which you don't want there anymore. Beyond those, though, there are really only two remedies which we see in tort law. The first and overwhelmingly dominant remedy is the payment of damages. In other words, the payment of money. Payment of damages in torts is based on compensating a person for the harm they've received in relation to their goods, their land, their body, their reputation, and so on. But there are a few things to note. First up, for some of the torts, particularly the 3 types of trespass, you don't actually need to show that you've suffered any particular damage. So if somebody trespasses on your land, for instance, you can take action in tort even if they don't harm the land at all, because just by being there, they've harmed your exclusive possession of the land. So that damage to your right of exclusive possession is enough. The second thing to note is that damages in tort are guided by a principle called restitutio in integrum, which means restoring to the uninjured state. In other words, the aim of the damages is to restore the person to the state they were in at the time of the tort. So damages are calculated as at the date of the tort, and then interest might be added. This is different to damages in contract law, where the court will also consider expectation damages or the loss of a profit. So damages are calculated in contract law at the date of the judgment. Don't get confused. In tort law, damages are calculated at the date of the tort. In contract law, they're calculated at the date of the judgment. In addition, however, sometimes the court will award what are called exemplary damages. The name gives you a pretty good hint about what these are. The aim of exemplary damages is to make an example of the tortfeasor so that they don't do it again, and so that others might realise that the potential costs of being a tortfeasor are so high that they shouldn't commit torts. Obviously, though, exemplary damages are more likely to be given for the torts that really do involve morally questionable conduct, things like false imprisonment, deceit, conspiracy, intimidation, defamation. And exemplary damages are really only likely to be given where there was some sense of malice in the conduct of the tortfeasor. Finally, the court can award what are called nominal damages. These take 2 forms. The first awards what is essentially a moral victory to the plaintiff, acknowledging that they've shown themselves to be the victim of a tort, but noting that there was no real damage to them. The second type of nominal damages does just the opposite, and we call this contemptuous damages. It awards a moral victory to the defendant. It says of the plaintiff that the plaintiff has technically shown that they were the victim of a tort, but that in all the circumstances they really have nothing to complain about, and the court will show its contempt for the claim by awarding a tiny amount of damages. Perhaps the most famous case of contemptuous damages was Dering and Uris. Władysław Dering was a doctor who worked in the Auschwitz concentration camp in the Second World War, where he carried out unlawful experimental medical procedures on Jewish prisoners. After the war, Leon Uris, a very famous author, wrote a book called Exodus about the foundation of modern Israel. In that book, he called out Dering. Dering sued for libel. Now, in those days in the UK, truth on its own was not a full defence to libel. In the trial, Uris brought forward other doctors who'd been at Auschwitz, including the amazing Dr. Adelaide Hoytval. If any of you want to learn about a truly amazing woman, look her up. She refused to perform improper surgeries, both at Auschwitz and the infamous Birkenau concentration camps. After hearing Dr. Hoytval's story, the jury found for Dering because he had technically been libelled, but the jury awarded him 1 halfpenny in damages, the smallest coin of the realm. Contemptuous damages indeed. Uris then wrote a wonderful fictionalised account in a novel called QB7, which stands for Queen's Bench Court 7. Every young lawyer should read that novel. Finally, other than damages, a plaintiff can seek an injunction. You've probably run into injunctions previously in your studies. They require someone to do something, or they require someone to refrain from doing something. Injunctions, and in particular what are called interlocutory injunctions, which can happen at an early stage in the trial, well, these can be particularly useful in defamation cases because they can stop the reputational harm from spreading. They're also useful in cases where there's an ongoing trespass, which the injunction can stop. However, injunctions are only used in situations where the court is convinced that whatever harm is being done by the alleged tort cannot be undone by an award of damages. Well, here we are. We've looked at torts protecting us from interference with our person, our goods, our land, our reputation. We've looked at torts affecting our economic circumstances, torts affecting those we rely on and those who rely on us. We've looked at torts affecting our enjoyment of our land and torts affecting the public's enjoyment of common space. We've looked at what happens when torts are committed by more than one person and when they're committed by someone else under our responsibility. We've looked at the remedies, mostly damages with the occasional injunction. And we're done. Stop the clock. All right, the crazy thing, of course, is that what we've done here is really only half of torts. And the overwhelming majority of actual legal disputes in the world of torts happen in the other half, the tort of negligence. For now, though, hopefully this video has given you a good primer or a good refresher. If you're about to start studying torts in detail, enjoy. And if you're revising for an exam, the very best of luck. Please don't forget to hit subscribe to my channel so that you can be among the first to know when the next of my 2-hour law courses is released. Please do share this video with your friends, and I'll see you again soon.